if you want to appear the examination of junior civil judge or the ADJs, you must have the goal. You must have the dream. You just should not apply. I will be write the exam whenever the examination schedule comes. You must have the goal. You must have the dream that I have to become a junior civil judge or the ADJ. If we without the goal, without the dream to become that post, don't apply for it. So there is a within 2 to 3 months, there will be examination of junior civil judges and ADJs. You start reading at least 10 hours a day. When the short 1 month the exam, you start at 15 hours a day. Definitely you will be succeeded. I will tell you very less competition for the lawyers in the only for the junior civil judges and the ADJs compared to other APS, PSPA, all other notifications. We are very fortunate. We are lucky to we are in such a post we are getting with less competition. So if you are becoming a junior civil judge, if you become a ADJ, your life is a glorious. So you got the opportunity of applying the post. Please prepare, work hard, write for the examination. So once you become a junior civil judge, your life is so beautiful, glorious. So work hard for 2 months so that you will achieve. Now I take you to the subject on CRPC and the Indian Penal Code and Evidence Act. I will take you the important parts where the questions are expected to appear for junior civil judges and ADJs. First, I will take you to CRPC. Every participant, every aspirant must know Section 154 CRPC. Under this, the criminal law is coming to force. According to Section 154 CRPC, any complaint made to the station house officer which discloses a cognizable offence, the station house officer invariably then and there he has to register a crime. He cannot wait for anything more for conducting a preliminary investigation. Every aspirant in section 154 CRPC is very important for all the ADJs who are appealing for any cognizable offence which refers in the complaint. The station house officer then and there he has to register an FIR. He cannot wait for a single minute. So it's 154 CRPC when a complaint made by any citizen, not only person against whom a crime is committed. Any person who has seen that incident also can make a complaint. It need not be a victim alone. It need not be a person against whom a crime is committed. Any person, neighbor, relative, any person who seen that incident can make a complaint to the nearest station house officer, requesting him to register in an appropriate provisions. When a complaint is received by the station house officer, which discloses a cognizable offence, he will register an FIR. If discloses a non-cognizable offence, keep it in mind. Cognizable offence and non-cognizable offence. A cognizable offence on which the station house officer has to register FIR and start investigation. A non-cognizable offence on which the station house officer has no authority to register an FIR. He has to enter that into a contents in the GD entry, then refer the matter to the nearest magistrate for seeking a permission for registration of FIR. So all the participants must know what is cognizable offence and non-cognizable offence. A non-cognizable offence, the station house officer has no authority to register an FIR without obtaining the permission from the learned magistrate. So these are the two important factors every aspirant who are appealing for the examinations must know. So Section 154 is very clear. And here, one of the important judgment, every aspirant lawyer, whoever may be, just the judgment of Lalita Kumari versus State of UP, everybody, it is a very, very important question. In at least 70 to 80% expected question, the judgment rendered by the Honorable Supreme Court in Lalita Kumari judgment is 5 aspects have been rendered. One is, according to Section 154 CRPC, the station house officer is bound to register an FIR if it is a disclosed a cognizable offence. However, in 5 types of cases, before registration of FIR, in what are 5 types of cases? Any complaint relating to a commercial transaction, because there is a 2 agreements between the 2 parties. There is a complaint is filed, he should not register FIR. He has to conduct a preliminary investigation. 5 types of cases where the complaint arises of a commercial transactions, matrimonial offences, corruption allegations, medical negligence, and the latches. Latches means an offence took place 2 months or 3 months back. Today, a complaint is filed before the station officer. Then he has to verify before registration of FIR. He has to verify and register the FIR. The five circumstances is a very, very important question for all the aspirants. Though you have tried, like, according to section 154 of CRPC, which empowers the investigation officer registering FIR, but as per the judgment of Lalita Kumari judgment, where an additional power is given to the investigation officer before registration of FIR in a complaint arises under a commercial transaction, matrimonial offences, corruption allegations, medical negligence, and the latches. In that 5 types of cases, the investigation officer need not register the FIR. He has given a time for 15 days to verify the genuinity of the allegations made in the complaint. If the allegations made in the complaint appears prima facie genuine, he is at liberty to register the FIR and proceed with the matter. Now 150, according to section 154 CRPC, the station house officer registered FIR and he has started the investigation. He is now searching for the accused. He is searching for the accused, whether an offence is committed or not. If the offence is committed, he is searching for the accused. Now the question arises, where offence is punishable within 7 years, where an offence is committed by the accused more than 7 years, what is the course left to the investigation officer? We are always talking about this is also one of the important judgments which everybody Arnesh Kumar versus State of Bihar. This every lawyer, every aspirant who studied law, this Arnesh Kumar versus State of Bihar, every person must know. If you wake up in a midnight, also you have to say what exactly the dictum laid down by the Honorable Supreme Court in Lalita Kumari and the Arnesh Kumar judgment, which is very, very important for the lawyer. According to judgment of Arnesh Kumar judgment, it says, according to section 41, where an accused, you have to know every person, because very 41A is a burning topic, not only for the lawyers, not only on every exam. We look at entire country, whatever the exam in connection to the law students, in connection with the competition in law, if where there is a question with regard to section 41A. So you must know, what exactly is the 41A. You are in a position to enlighten others. What exactly the judgment of the Honorable Supreme Court in Arnesh Kumar judgment is, where an accused committed an offence up to 7 years, the investigation officer has liberty to issue 41A CRPC notice and leave liberty of the accused without arresting him. That is, you have to use it language. By way of the judgment rendered by the Honorable Supreme Court in case of Arnesh Kumar, empowering the investigation officer, where offence is punishable up to 7 years, he can have a discretion given to him to give 41A CRPC and leave liberty of the accused without arresting him. It is not by way of an amendment of 41A. It is the judgment rendered by the Honorable Supreme Court that has been power acquired to the investigation officer, not from the statute. So you are in a position to understand. Now the question arises you. Now the very important question arises you. The Honorable Supreme Court, in judgment of Arnesh Kumar, where empowering the investigation officer, where an accused committed up to 7 years, in all cases, whether the investigation officer bound to give 41A and is what we gave you. That's another question now. That may pose in the question paper in the APP or the magistrate. In all cases, by virtue of the judgment rendered by Arnesh Kumar, their investigation officer in all cases bound to give a 41A CRPC. No. If you look at the Arnesh Kumar judgment, last paragraph, the investigation officer is directed to follow 41 CRPC basis, where the offence is punishable up to 7 years. However, if the investigation officer feels necessary to arrest the accused, where the offence is punishable up to 7 years, also a liberty is given to the investigation officer, provided you must record the reasons. The concrete reasons have to be, we cannot routinely arrest the accused. The investigation officer has to give a concrete reason. On these grounds, I am taking a decision, though he has committed up to 7 years, but I have taken a decision to arrest the accused. These are the reasons. Because he is from out of state, or without arresting, I cannot seize any article. Therefore, some cogent reasons has to be given in the checklist. Then alone he can arrest him. It is not complete power given to the investigation officer not to arrest. He had a power to arrest the accused where the offence is punishable up to 7 years also. The investigation officer had a power to arrest the accused. The power given under the Anish Kumar is not a blanket power given to the investigation officer. It is a discretion given to the investigation officer whether go for arrest. If you want to go for an arrest, you have to show the reasons. If you want to issue a 41 years CRPC, you also have to give the reasons. That yes, in these circumstances, a person is a very is a teacher working in the same locality. There is no possibility of escaping from this jurisdiction. I feel that he will be appealing the trial. Therefore, they cannot be escaping from the process of law. Therefore, I am issuing a 41A. If you want to file a 41A CRPC notice also, he has to give a reasons. If you want to arrest also, he has to give a reasons. That reason subject to satisfaction to the learned magistrate, not for himself. Okay. So that question you have to understand. It's not a complete power which has been vested to the investigation of it. If you want to arrest, he has to show the reasons. If reasons must be subject to satisfaction to the learned magistrate. It is not the reasons which is satisfaction to him. It is not an arbitrary. He has to show the reason to complete take him to the custody within 7 years. Now the reasons is Supreme Court's judgment, which is also because I am telling you, Lalita Kumari judgment and Rajesh Kumar judgment, every member knows, must be knows. It's very, very important. It's not a complete power given to the investigation officer that the way the offence is committed up to 7 years, he has to issue 41. No, it is a wisdom whether go for arrest or not to go for it. Either way, he has to show the cogent reasons. That reasons must be subjected to satisfaction of the magistrate. In a given case, very, very important subject for the money. In a given case, where an accused has committed up below 7 years, the investigation officer chosen to arrest him, shown some grounds, and produced before the magistrate. The magistrate, after going into the entire record, if he feels that the grounds shown by the investigation officer is not proper, he can grant bail, he can discharge. He cannot send back to the police station. Keep it in mind. We are always saying that the magistrate has not taken the remand, therefore he has gone to the police station. No, you being a lawyer, you must satisfy the court the ground shown by him is not in accordance with law, that are not the ground, therefore discharge the accused or grant the bail. But the learned magistrate cannot send back to the police station. Either to grant bail or either to discharge the accused from there, asking him to appear before the trial, or you can accept the remand. These three categories can be taken by the learned magistrate. If they satisfy the grounds given by the magistrate, the investigation officer, they can accept the remand or send it back, deliver. This is the exact section 41 ACRPC notice. So every lawyer must know about the Anish Kumar judgment and section 41 ACRPC notice. Now further, it is very important boring topic. I will little later. Okay, where the accused committed up to 7 years, the investigation officer issued a 41A1 CRPC notice giving the liberty of the investigation officer. After some time, if the investigation officer receives some important evidence which connects, which is the serious in nature, then even after issuing a 41A CRPC notice also, in exercising the power under section 41A3, he can still arrest the accused. In filing of charge sheet, the power of arrest with the investigation officer. If the power of arrest is always there in the hands of the investigation officer, the only rider put on by the Honorable Supreme Court in order to overlook the arbitrary arrest of the investigation officer, in order to avoid the routine arrest of the investigation officer, section 41A has been inserted. That has been upheld by the Honorable Supreme Court in Anish Kumar judgment, where there are some directed the investigation officer. There should not be a routine arrest. There should not be an arbitrary arrest. Where an offence is punishable up to 7 years, you have to give the reasons. That reasons should be subject to satisfactory punishment. Even after 41A should also the investigation officer in filing a charge sheet, the care of arrest always in the minds of the accused. Here, every possibility, showing the reasons, obtaining the evidence, he can arrest the accused. Now, Here, section 4, the investigation officer registered FIR. If you want to catch the accused, he can follow 41A. Now the question arises, where an accused is committed, this is very another important judgment everybody must know. Where Anish Kumar judgment deals with where the offence is punished up to 7 years, they have a liberty. Where in a cases where an accused committed more than 7 years also, can the investigation officer power to release him or power to arrest him? Now another important question may not known by you, but the Honorable Supreme Court in recent judgment Siddharth versus State of Union of India, where their lordships have held even any punishment, the investigation officer pleads. Siddharth versus the Union of India, very important judgment. Recently, Honorable Supreme Court held empowering the investigation officer, where irrespective of provisions the accused is committed, whether it is life imprisonment, where up to 7 years or the danger, whatever the imprisonment is irrelevant. If the investigation officer feels that the arrest is not necessary, he can be arrested. Without arresting the accused, he can file a charge sheet. So that is a beautiful judgment which is rendered by the Honorable Supreme Court. Why the Honorable Supreme Court has given such a power to the investigation officer? Recently, I gave one opinion. I will tell you very important question. Where an accused is 70 years old, there was one quarrel between the neighbor and them. Unfortunately, he has taken the stone and beaten him. It has met here and this is one that. The accused is 70 years, thereafter which is shocked, he is totally bedridden. 304(2) is charged. It is a punishment up to 10 years. Now what will the accused is totally bedridden. Without arresting him, the investigation officer cannot file a charge sheet because it is a more than 7 years. But I gave an opinion saying that the Siddharth versus State of Union of India is empowering, showing the reason because the accused is bedridden. He cannot take him into the police station. Show that reason. Get the medical record. Satisfy the court. Without arresting the accused, he has filed a charge sheet where an offence is punishable up to 10. In a required cases, where genuine cases are there, even when such is the power which has been given, it's an unlimited power given to the investigation officer under section 41A. Whatever the case, whatever that is the power. The Supreme Court or any court cannot direct the investigation officer to arrest a particular person. It is a wisdom, it is a discretion of the investigation officer under section 41A, 41 of CRPC. This question is very important. The law on which Siddharth versus Union of India, Anish Kumar judgment and the Lalita Kumari judgment, which deals with the power of the investigation officer, under what circumstances he can exercise his power under section 41. This is the complete power, arrest or not to arrest under section 41 gets. Now, FIR is registered, investigation officer arrested the accused, filed a charge sheet. Now it's a murder case. For example, it's a murder case. The investigation officer, entire investigation is completed and filed a charge sheet. Now what is the procedure next? What is to be followed by what is the procedure? Every aspirant must know, because what is the cognizance? Under what circumstances cognizance has been taken? Here, the FIR is registered, the accused arrested or not to arrested, the particular issue or not, investigation is completed, and the charge sheet is filed before the learned magistrate, concerned magistrate. Now, the learned magistrate has to look into the entire charge sheet and document which is annexed to the charge sheet. Whether the prima facie case is made out against the accused or not is to be taken into consideration before taking the cognizance. We are under routine manner meeting because of bound and duty. What is the cognizable? What is the cognizance taken? It's very important. When under what circumstances the learner, because you are appealing for the JCJ, it is a very important question. When a court will take a cognizance in the report filed by the police officer. Report means the charge sheet under section 173. Under what circumstances? It's a very important question for the persons who are appealing for the ADJs and the JCJ, when the court can take a cognizance on the report filed by the investigation officer. Report means it's charge sheet. What is then investigation is completed? Charge sheet filed. Now the question of exercising the power by the learned magistrate. In case it is a triable by the sessions court, though it is filed a charge sheet for the court, the learned magistrate, the jurisdictional magistrate has to examine the entire contents, the entire documents which is annexed in the charge sheet. If the prima facie case is not made out, the court cannot take cognizance of the accused, it can be discharged therein. If the court convinces prima facie, Prima facie, that the allegations made in the 161 and the material collected by the investigation officer, prima facie established the contents in the IPC mentioned in the charge sheet, the learned magistrate can take the cognizance under section 191B. Very, very important penal voucher. The learned magistrate will take the cognizance exercising the power under section 191B of CRPC. They will take the cognizance of that charge sheet. It will be numbered. After taking cognizance, next goes to the learned magistrate is to comply section 207 and 208 of CRPC. What is that? This is very important every month. But aspirant, after taking cognizance, the notice has to be given to the accused, asking him to appear before the learned magistrate and comply section 207 and 208 of the CRPC. What does it say? He has to give the entire papers, charge sheet, and the document is to give the learned magistrate by exercising the power under section 207 and 208 of the CRPC. This is the next step which is available to the learned magistrate. Now section 207, 208 of the CRPC complied, given to the material paper. Cognizance has been taken under section 190B. Thereafter, section 207(8) has been complied by publishing the documents to the investigator, to the accused. The next course is the learned magistrate has to commit the case to the sessions court under section 209 of CRPC. The learned magistrate has to commit the case to the sessions court. There, the entire process on the case, where the case exclusively triable by the magistrate. Therefore, the entire process on which complaint, FIR, starting investigation, filing a charge sheet, every aspirant must know cognizable and non-cognizable section 41, under what circumstances the investigation officer arrest, under what circumstances investigation may not arrest, and after arresting, and what if he chosen to not arrest after filing a charge sheet, what is the power of the magistrate? These are the very key aspects, these steps. Every aspirant who are appearing for the exam must do. These are simple procedures. After you begin in the magistrate, if you become in the magistrate also, these are the procedures you have to follow. Now, the matter has been committed to the sessions court. The sessions court will fix a date for appearance of the accused. Accused will appear. After appearing, then the court will examine whether all the procedure under section 190B and section 207, 208 complied or not. After doing that, a schedule will be fixed. There are so many witnesses in the schedule. The schedule will be fixed. Now, here another important, now trial will commence. Every aspirant must know what is the types of examination. According to section 135 of Indian Penal, now the schedule is commencing, trial is commencing. The entire procedure on the procedure has been completed. Now the court is trying the case, whether the accused is committing the case or not committing the case. The court is examining after verifying the oral evidence and the document. What is the oral evidence? You must know. What is the oral evidence? Every participant, what is the oral evidence? Which the oral evidence which is given oral in the court and the 161 CRPC statement the investigation officer called as oral evidence. Oral evidence is the evidence which is coming from the mouth of the witness is the oral evidence. A documentary evidence is the documentary which the prosecution relies and proving before the witness. Not on simple collection is not proving. You have to prove the document to an author. For example, a report given by the FSL. The investigation officer cannot prove that. The FSL expert has to come. Yes, this is the report given by me. This is the content mentioned in the FSL is proper. Therefore, it has to be. Every document, keep it in how a document should be marked. What is the oral evidence? What is the documentary evidence? What is the difference between the oral evidence and documentary evidence? How a document should be marked during the trial? These are the very questions, very, very important questions. Oral evidence is the oral evidence which is coming out from the witness in the 161 statement and the evidence which is additional for the court. The documentary evidence, the documents which is collected by the investigation officer, which marking to the author, not by anyone else. That should be marked to an author, then only it's an evidence. For example, I have collected so many documents. The investigation officer, so many. If you look at the entire document, you feel that yes, accused has committed an offense. But it is not marked in the court, though it is there in the file. The entire document, the FSL report shows yes, there is a poisonous substances. It shows there was an injury. The entire record shows that the accused has committed. but you have not proved it. Though the entire document is there before the court, but it is not marked. Court cannot rely on the term unless the document is marked to a proper person, a author of the document. That is what proving the document. Mere filing of a document before the court is not sufficient to prove the document. You have to prove the document through marking a person who is the author of the document. Therefore, what is oral evidence and what is the documentary evidence must be. Now, the evidence is starting. What is the evidence? The examiner, according to section 135 to 137 of the Indian Evidence Act, says examination in chief, cross-examination, and the re-examination. Here also, the very, very important question arises: what is the leading question? What is the examination in chief? What is the cross-examination? Is everybody had a right to cross-examine the person? What re-examination of witness is automatic? It is automatic right? No. Sometimes what we ask is that re-examination is automatic right of a party, or in the cross-examination in all questions can be put through leading question, or can examination in chief leading question can be asked? These are the important questions you have to frame. These are the types on which the questions may appear. Can a leading question can be asked in examination chief? Can all facts can be proved by leading examination in the cross-examination? When the examination chief is over, cross-examination is over, can the re-examination is automatic right of the prosecution and the accused? These are very important questions may ask in small bits. 3 question mark question in the front. So examination in chief means whatever the witness stated in 161 CRPC statement, he can be deposed before the court. That is called examination in chief. Means whatever the facts stated to the investigation officer in 161 CRPC, the same thing is accusing before the court called as examination in chief. Whatever stated by the witness, whether the victim or the complainant or the eyewitnesses or the circumstances, whatever the evidence which has been reduced in 161 CRPC and coming before the court and reducing the same thing before the court called an examination in chief. Keep it in mind. Then once an examination in chief over, now the right of the accused, the learned counsel who is appealing for the accused had an absolute right. Cross-examination is an absolute right of the accused. Keep it in mind. It's an absolute right. No one can even court, prosecution, no one else can stop it. It's an absolute cross-examination of a witness having whom spoken in a cross-examination is an absolute right of the accused. He can ask any question. He can impugn the character of the witness. And the sky is the limit. Any questions can be asked in the cross-examination. Any question, whether it is relevant to the facts in the case or whether irrelevant, whatever, subject to satisfaction to the learned magistrate who is sitting on the bed, but it's a right. He can impeach the character of the witness. He can ask any questions since birth of that witness. You cannot stop asking the questions in the process. But that is not the case in the examination in chief. You have to confine to the case of the prosecution. And you have to confine, you should not ask any leading question to the examination in chief. Keep it in mind. It is a the prosecution must be confined to the 161 CRPC statement that has to become an examination in chief. But the cross-examination, the sky is the limit. We cannot stop putting the question to the witness which is appearing in the witness bag. Sometimes if the irrelevant question feels, the learned public prosecutor may bring it to the notice of the court, but he cannot stop the learning counsellor asking for it. The court will examine whether it is really irrelevant. Then the court will examine and ask the learned defense counsel that case, that question will not be relevant. Again, it is a discretion given to the judge. The prosecutor has no role to stop the counsel for the exam. Now the examination chief is over, cross-examination over, now the re-examination. Under what circumstances a re-examination coming to any doubt during the course of the examination in chief or the cross-examination, any ambiguity with regard to the statement made by the witness. It is very doubtful. Any ambiguity, in order to resolve the ambiguity, arises in examination in chief and the cross-examination, or any fact is not stated in examination in chief, but the first time a fact which is important stated in the cross-examination, the learned public prosecutor must ask the permission of the court. It is not an automatic right of the prosecution. Keep it in mind, re-examination is not automatic right of the defense or the learned public prosecutor. The court, we have to convince the court. This is a new fact. Came to light in the examination chief. He has stated one thing in the examination chief. He has stated another thing in the cross-examination. In order to resolve, in order to come to truth, in order to arrive at the right conclusion, I want you to ask one question. You have to disclose that question to the honorable judge. If the honorable court judge feels that the question is relevant to ask the witness, then the court will permit to re-examination. In all cases, re-examination is not permissible. It is to any new fact which creating an ambiguity. Then alone, either defense counsel or the prosecution can seek the permission from the court for asking a re-examination. This examination chief, cross-examination, and the re-examination over. For example, a witness coming in a witness box is deciding the statement. I do not know anything about the case. The police officer obtained my signature on a white paper. I do not know. He's reciting the entire statement of 161 here. Earlier we talked about the contested matter, where the witness supported examination chief, cross-examination, and the rest. Now, the complainant gave a complaint. FIR is registered, 161 statement and the 164 statement, which has been effectively supported by the witness. When the witness coming in the witness box, when the question asked by the prosecutor, the witness says, I do not know anything about the case. Then the prosecutor, in exercising the power under section 154, seeks the permission of the court to declare hostile. Here is a very important question. Under what circumstances the prosecution declare hostile? It's not hostile, it's an unfriendly to the prosecution. That is the language used in evidence act. Nowhere hostile is being defined in the evidence act. Just normally we are using it. It's an unfriendly to the prosecution. In exercising the power under section 154 of the Indian Evidence Act, the permission should be sought by the public prosecutor who is in charge of the case, seek permission from the court and ask for declare the hostile witness. Then ask further for cross-examination of the witness. It is not an automatic again. You have to seek the permission from the court to declare the witness hostile, and the prosecution has a right to cross-examine. Whatever you stated in the complaint and the 161 statement is true. In compromising with the accused, you are deposing false here. That is the statement normally the learned public prosecutor will ask. So the cross-examination right is accrued to the prosecution here because the witness is hostile. In a contested matter, right of cross-examination is available to defense counsel. But in the hostile matter, it is not right, absolute right to the prosecution. We have to take the permission from the court. In a bare contested matter, permission is not required. It's an absolute right. Here, prosecution when the witness declared hostile, you have to seek permission. If the court grants permission only, you have to ask the cross-examination. Limited extent to the facts and circumstances of that case, you cannot be asked the irrelevant question as your defense counsel is asking in the contested matter. The prosecutor has right to ask the facts which is relevant to the facts and circumstances of the case. Not beyond that, the learned public prosecutor has no business to ask more questions to other than the case. So here the cross-examination is the asked by the prosecutor. Now, important, so many times the youngsters will confuse it. Now, examination chief over cross-examination, re-exam, all the entire trial is commenced. Now, what is the omissions and the contradictions? Very, very important subject. There definitely ADJ or the justice say definitely there will be a question. What is the omissions? What are the contradictions? Till now, the youngsters may not know because very gray area which you have to concentrate to understand what is the omissions, what are the contradictions, what are the improvements. These are the three aspects. Every aspirant, every law student, every lawyer who is appealing for more particularly criminal side and also civil side. Very well, because Indian Evidence Act applicable to civil proceeding and also the criminal proceeding. What is the omissions? What is the contradiction? What is the improvement? Which are the three important facts must be known by every lawyer, every aspirant who are appealing for the magistrate or the judiciary. What is the omission? Keep it in mind. What is the omission? Very simple. The witness. Keep it in omission is the witness which is not deposed in 161 CRS statement. The fact is first time stating before the court is called omission. A fact which is not stated to the investigation officer in the 161 statement, first time in the evidence In the court, that fact is stated by the witness called as omission. For example, in 161 statement, this witness stated that the accused beaten me with hands. With hands. That is the 161 statement. In the court, the witness says not only hands has beaten with the sticks. This is called omission. The beating of sticks was not stated by the witness in the 161 statement before the investigation officer. A new fact is coming in the evidence. What? Not only hand, he has beaten with sticks. This is called omission. The fact which is not stated before the investigation officer under section 161 CRPC statement, the first time the fact is being stated in the examination chief in the evidence called the omission. The fact which is not stated to the investigation officer as stated before the court is called the omission. Simple language, very, it's not difficult question, but till today my brothers will not understand what exactly. If you know the omission, if you know the contradiction, definitely 90% of the case you will believe in the criminal law. If you are thorough with the omissions, if you are thorough with the contradictions, if you are thorough with the improvement, definitely you will create a doubt. What is, we are in adversarial criminal justice system, not in equatorial criminal justice. Here also you must know. What is the adversarial criminal justice only prevailing in India? What is adversarial criminal justice? Anybody knows this? Adversarial criminal justice system is prevailing in India means the accused who has committed the offence is presumed to be innocent. Entire burden lies on the prosecution to prove the offence. That is called adversarial criminal justice system, which is prevailing only in India. An accused committed an offence is presumed to be innocent. The entire burden lies on the prosecution to prove that he is the person has to commit the offence. That is also beyond reasonable doubt, not a doubt which is just based on oral evidence and the documentary evidence. The accused is committed is not in not. There should not a simple doubt in the minds of the court. If any simple doubt raised by the defense counsel to the accused, then the benefit of doubt is given to the accused. That is the reason why you must thorough with the omissions and the contradiction. Any omission, any contradiction will may go into the root of the matter, then entertains doubt in the mind of the court. So by the witness said in the 161 statement only hand now says no, something is wrong here. Then the court will entertain his doubt. It is called omission. Here the benefit of doubt given to them. Therefore, every lawyer must know what exactly the omission. So we are creating a doubt. Why a witness stated before the investigation of only hand? Now this before the court not only hand can still say there is a clear omission. Therefore, court can entertain the doubt. Therefore, prosecution is not proving beyond reasonable doubt. It is creating some doubt. Therefore, adversarial. So many when I am attending the additional 50 exam, this question: what is the adversarial criminal justice? The adversarial criminal justice system is to prove the entire burden on the prosecution, entire burden on the victim to prove the case that the accused has committed beyond reasonable doubt. A single doubt is entertained by the court, then the benefit of doubt is given to it. That is called omission. What is contradiction? The fact which is not stated at all, was stated before the magistrate. There was no issue at all in the case before the investigation. First time, irrelevant fact has been taken before the court. For example, a witness stated that the accused beaten me in front of the Adalat, FIR is registered, investigation is completed and charge sheet filed. Now the witness is coming before the court saying that these accused beaten me here and not in the Adalat. It's called as a contradiction. It's totally contradiction. The scene of offense is totally changed. This is called contradiction. A contradiction between 161 CRPC statement and the evidence which is that is called totally contradiction. The scene of offense totally changed. It is called contradiction. Keep it in mind. A witness stated before the investigation officer in the complaint called the 161 statement that the accused beaten me in front of the Adalat. When the witness comes before the court saying that not in Adalat, the accused beaten me here in Annakonda police station. This is called totally contradictory case to the prosecution. So the entire case goes. This is called contradiction. So every criminal lawyer and every civil lawyer and all the lawyers who are appearing from JCJ and ADJ must know what is omission and what is contradiction. What is the improvement? What is the improvement? What is improvement? For example, improvement also very important in a civil and a criminal. What is improvement? For example, the witness stated before the 161 statement that accused beaten me I was so conscious. I was taken to the hospital. And their doctors are treated me. I comfortably came to the hospital. Now the witness box, witness said, yes, accused beaten me. At the time of it, I felt unconscious. It is an improvement. It is an improvement in the statement given in the 161. When the accused beaten me, I felt unconscious. I do not know what happened later. That is a contradictory improvement to the police case and the evidence which is called. So these are the three important factors. If you want to become a criminal lawyer, if you want to be a effective criminal lawyer, or whatever the subject you are taking or appealing for the editor, you must know the omission, contradiction, and improvement. This is the area where to becoming a successful lawyer, not only the appealing for the competitive examination, if you want to compete, that is where the cases are winning. Not by effectively working hard. Just the learned defense counsels are creating the doubts by showing an omission, by showing a contradiction, by showing an improvement. Therefore, the evidence given by the witness is not truthworthy. Therefore, acquit the accused. That is where we are not getting the convictions. That is, we are living in adversarial criminal justice system where the entire burden lies on the prosecution, lies on the police, lies on the victim to prove the case against the accused. He is presumed to be innocent. He maintains silence. He should not ask any question. He has committed an offense. He will be the silent spectator before the court till pronouncing the verdict. The entire burden lies on the prosecution. What is an equatorial criminal justice? There is important these two questions. What is the adversarial criminal justice system? What is equatorial criminal justice system? Which is prevailing in the entire world, except in India. What is the equatorial criminal justice system? Is the burden lies on the accused to disprove the case. When the prosecution files a charge sheet, collecting the document, saying that these are the person, he is the person accused who is committed an offense, therefore they are prosecuting the accused and they are filing the charge. Now the time starts on the accused to disprove that entire allegation. The burden shifts to the accused to disprove the prosecution. The entire burden shifts on the accused to disprove the case, which is filed by the prosecution, which is not prevailing in India. We are in adversarial criminal justice system. In the entire country, an equatorial criminal justice system is prevailing because there the burden lies on the accused to disprove the prosecution. Where in adversarial criminal justice system, where the accused, the prosecution burden lies on to the entire case. Therefore, these are the factors will play very important factors to decide the entire criminal case. Now, as a prosecutor, I'll ask this. Now the question may appear: all the omissions and the contradictions will it be ground because I'm in criminal side after enlightened because the topic has assigned me to teach on criminal law. All the omissions, all the contradictions, all the improvement raised by the accused will automatically give benefit of right to the accused. No, recently the Honorable Supreme Court said all the omissions, all the contradictions, all the improvement raised by the accused is not in ground for acquittal likelihood unless that is material in nature, which create total doubt on the court. All the omissions and the question maker, whatever the omission, contradiction, improvement is automatically given to the benefit of right to the accused. No, that improvements, that contradictions, that improvement which is a material in nature, then alone the court has to all omissions, all contradictions, all improvement will not give absolute right to the accused to acquit the accused. That should be material in nature. It's create complete doubt in the court. That's a slightly law has been changed. Recently, all omissions, in the contradictions, and improvement complete doubt should not be given to the prosecution. That improvements and the contradictions and improvement should be material, complete doubt on the minds of the court. Then only all material omissions, contradictions, omissions will have to be taken into consideration to decide if innocence of the accused. Now, examination chief is over, cross-examination over, re-examination over. Now, the matter is posted. Termination of trial. You have to keep in language. It is not trial is over. No, termination of trial. This is the legal language. When court can terminate the trial, trial is all the witnesses cited in the charge sheet, including the investigation officer. Over, then it is called as termination of trial. The court can terminate the trial and post it for the 30 CRPC statement. What is it? In every case, examination of 313 evidence is very important. So, very important question. What were 313 CRPC statement and examination should be conducted by the magistrate? Very important question may come in the court. What is the questions? What are the purpose on which 313 examination should be committed? What are the types of questions will ask? Any incriminating evidence which is coming against the accused in the evidence can be put to the accused and ask for an answer. This is called 313 CRPC examination of 313. Keep it in mind, any incriminating evidence coming against the accused in the trial, put it to the accused and get the answer recording in his language called 313 CRPC. So many times this question is appeared in the ADJ examination, JCJ examination, and ATP examination. Every alternate question paper conducting of 313 CRPC examination mandatory, or what are the types of questions will you ask in these exams? This is any incriminating evidence which summing evidence against the accused put by the court to the accused and invite him in answer and record it for 313 examination. Now, next question comes, can a 313 CRPC examination, can accused submit any documents to the court? This is recent development of law. Recent court may ask, when a 313 CRPC examination, can accused submit any documents supporting him? Is the question come in 3 marks or 4 marks? It's very important question. Yes. The recent Supreme Court judgment says the accused, because he is a silent spectator, nowhere he has been participated in the proceeding. He is just silent spectator. He never had an adherence to the appearing the trial. Therefore, 313 examination there is a direct contact with the court and the accused. Therefore, if he is relying any document to disprove the prosecution case or to support his case, he can make any documents to the court at the time of 313 CRPC. Therefore, the question may come, when any accused has a right to submit any document to the court. Yes, absolutely, he had a right to submit any number of documents at the time of 313 CRPC. Now, what is the validity of the documents? Now, next question comes. It has not marked. Justice presenting a document to the court. What is the evidentiary value of the court? The court has to receive the document. The court only can look into the document. If that document can influence the minds of the court to deciding the court will take into consideration at the time of appreciating to decide his guilt or innocence of the accused. It is not mandatory that I have given a document, you are not at all considered. He cannot ask this question. Court can influence that document. If really the accused has not, by virtue of the document, if the court comes to the conclusion that yes, there is a doubt creating, there is no possibility of committing the accused, then the court can refer that document and acquit the accused. Therefore, it is not mandatory on the part of the court to consider all the document, but it can only persuade the court. It persuades the mind of the court when they appreciate the evidence to decide the guilt, or you use language, guilt or innocence. You have to use the language when you are writing exam. The examiner value will appreciate it. Guilt to decide guilt or innocence of the accused, court will appreciate the document in order to prove the case of the prosecution. Now, is that an examination over? Now it is for the arguments. Every learned defense counsel and accused person had a right to file a written argument. Okay, the question when I appeared, it is a mandatory right of the parties to file a written argument. Under what section? Therefore, according to section 314 CRPC, if you are not reporting your argument before the court, you have a great power to reduce in writing, file in a form of written arguments before the court. That is the power has been given to under section 314 of CRPC. This is also very, very important power which is given to all the parties to file written argument before the court. You can also make an oral argument and equally you can file a written argument. Or you can not to argue, you can file a written argument. Both the options will be given to the prosecution and to the accused, by which you can comprehensively, you can write all facts, whatever your case, what is the prosecution case, what is the lacunas in the investigation, what exactly is the evidence, where is the contradiction, how an improvement, how a conflicts, you can detail, you can write in the, but consideration is very important. When you write the written argument, the court has to look into the entire facts based on which the entire case is to be decided, not the judgment. If the court feels that the accused is committed the offence, court can convict the accused, or the court feels that the prosecution is not to the case of the prosecution beyond reasonable doubt, the court can acquit. Now the entire proceeding from the complaint to the pronouncement of judgment is over. Now sometimes this is also section 311 CRPC is very important for all the aspirants. So many times, what is the evidence, what under what circumstances, under what stage, where 311 CRPC statement of petition will be filed before the. This is also very important. Where I am important that sections only, which is very important. Which the case, the sections which are not important are not taken, and section 311 CRPC is very important for the lawyers and the aspirants. Section 311 CRPC, the witness which is not added to the charge sheet can bring the witness at any time by filing a 311 CRPC. Till pronounce, this right is available for all accused and the prosecutor. Till pronouncing of judgment, any time it can be filed 311 CRPC. It is not during the course of the trial, not during the court of 313 CRPC, not in the same judgment. Till tomorrow's judgment is pronouncing, today also you have a right to file section 311 CRPC expressing the facts. This as the witness has not been examined in the trial. This is a witness is very important for the prosecution or the accused in order to bring the truth. Either in favor of the prosecution or in favor of the accused. In examination of the accused, the witness is very important for the accused or the prosecution. The court is the feels that whatever the facts shown by the prosecution or accused in 311 CRPC, the court feels that the examination of that party is relevant in order to decide the case, in order to arrive at true conclusion of the case, either prosecution victim or the accused. The court can entertain that application. All any witness, though he has not examined by the investigation officer, he has no bearing picture. But first time that witness is coming before the court by way of 311. This power, a very important question and very important section 311 CRPC. Any accused or an accused, the prosecution has the liberty to file a 311 CRPC at any stage till pronouncing of judgment, can file, bring any new witness to adduce their evidence on behalf of the person who filed a 311 CRPC. This is where a very important provision which is incorporated. The Supreme Court has given extensive consideration. It's a right of the party to file 311. It is the right. The court cannot easily reject it. Court has to give it. It is 90% court cannot reject. No, if they reject, I cannot entertain 311. You entertain and decide it, and recall the statement and then decide. It's just mere lacunas, mere delay. You cannot reject 311. It's a matter of right to the accused and the prosecution. Now, another important question. It may appear by way of form of an examination. The entire charge sheet is filed. The investigation officer and some documents is not collected. Now, the prosecution relied that documents, though it is not there in the investigation or the charge sheet, during the trial, and witness gets said these are the documents is very important, which is not filed by the investigation officer, he is filed before the court. This court also may ask the question also may come. Can the prosecution file a documents during the course of the trial? Under what law? According to section 242 before the magistrate, 242 of CRPC, any time can prosecution file 242 CRPC petition before the magistrate, not in section 4. According to section 242 CRPC petition, any document which is relied by the witness can file before the court at first time. Though investigation officer is collected, the prosecution is empowered to file section 242 CRPC before bringing certain documents, filing before the court and receive. This is also one of the important criminal conduct. Even after you are becoming a magistrate, even after you becoming a DJ, even after you becoming a deputy, this is an important criminal conduct which is available for the during the trial of the sessions court, 230 CRPC, till today my prosecutor, every time tells the prosecutor, even conducting a trial before a sessions court, the prosecution has power under section 230 CRPC to file any documents by invoking section 230 CRPC. It is not relevant for the APTs and the magistrate, but it's very relevant for any examination. During the session trial, any time by exercising section 230 CRPC provision, though investigation officer not collected document, he has not filed a charge sheet, but the learning additional public prosecutor who in charge of that sessions court, whenever a new document came to his notice by way of a witness, he can file under section 230 CRPC before the sessions court at any time. So these are the important penal provisions which, if you know this, you are not missing a single question from CR. Whatever sections which are now informed you under the CRPC and the Indian Act 135 to 136 to 137, you will cover entire evidence act in the CRPC. Now, just I will, what is evidence? I will tell you what is the CRPC, what is the evidence act, what is the Indian Penal Code. This is the criminal law which prevailing in the India to prosecute any person who has committed the offence. CRPC laying a procedure, showing a procedure to the investigation officer and the magistrate or the sessions court how to conduct investigation, how to conduct the trial. It is a procedural section. It is not in penal in nature. It shows the procedure. Any difficulty arises in the investigation, any difficulty arises in the trial, the CRPC provides a procedure to overcome that. It's only a procedure in nature. To exercising that power, we are overcoming the defects or whatever the investigation officer and the trial, whatever before the Supreme Court or the High Court, it is only a procedural nature. IPC is only penal provision. It is not provides a procedure or it's only a penal. It only speaks about punishment. That's all. It's only, for example, a person beaten me. He will be charged in a paper with the IPC. It's only a penal provision. Then how to conduct? CRPC says. How to conduct a trial in the evidence act says. Every learned judge must be thorough from section 6 to section 55 to Indian Evidence Act. Every document which you collected under what section of the Indian Evidence Act is relevant has to be established. If you are becoming a thorough lawyer, if you become a ADJ as a magistrate, you must be very thorough from section 6 to section 55 of the Indian Evidence Act. What does it say? Every document, every evidence which is collected by the prosecution, which is collected by the accused, should be fixed in any of the sections in the Evidence Act. Otherwise, it is not admissible. For example, a victim comes and says, Mr. Satyanarayana, public prosecutor, is beaten me in front of the Adalat. That is the case of the victim. The accused comes and says, Satyanarayana comes and says, the day and the time when the victim says that I beaten, I am in Mumbai. I was not there at the time. This statement is relevant under what section? Section 11 of the Indian Evidence Act. You can ask the question. This statement of the accused is relevant under section 11, alibi. So every document is supported by any of the section of section 6 to 55 Evidence Act. This statement was made by the accused, saying that I was not there. As alleged by the accused, I was in Mumbai. This is why my train ticket. This is relevant under section 11 of the Indian Evidence Act. Court has to bound to accept it because you are fixing the court under section 11 of the Indian Evidence Act. So any document, they are forgetting the Indian Evidence Act. Any evidence collected with the prosecution within the parameters of section 6 to section 55 of the Indian. For example, a doctor examines the victim, gives a medical opinion which is relevant under section 45 of the Indian Evidence Act. Court may ask this medical certificate, this evidence, how it is relevant? Which is relevant under section 45 of the Indian Evidence Act, expert opinion. So keep it in mind. If you thorough the section 6 to 55 of Indian Evidence Act, you are perfectly, you are a civil lawyer in every evidence, every document. Whatever you collected, it should be supported by any of the section 6 to 55. It should be fixed anywhere. For example, the accused is arrested. He has taken to the police station. He reduced in the confession where he stated that I was committed the offence. He has admitted before the police. And the remand report and the confession statement is filed before the court. Now the lovely defense counsel come and say the statement recorded by the investigation officer accused is irrelevant as per section 24 of the Criminal Act. So it is coming in his favor. 24 of section 24 of the Criminal Act says any statement taken by the investigation inducement is at all irrelevant. Therefore, you are relying on section 24. It is coming under section 24 of the period. So you are getting the acquittal. So any evidence which is relied, which is in consonance with any of these sections, it has to be fixed in any of the sections. You cannot more than that. Any evidence you have collected, the court asks under what section it is relevant. For example, confession given by the accused in the investigation officer is totally irrelevant by way of section 22. If you make the statement, the confession given to the by the accused to the police officer is irrelevant. So what we ask, under what provision of that it is irrelevant? Section 25 of the Indian Penal Code. If we chose this power, court has to be accepted. Therefore, a confession given during the course. We know this argument. Any going? Yes. So, okay, please. No worry, madam. Thank you.
5 minutes break.